The SEC is increasing its examination of cryptocurrency. The Securities and Exchange Commission is increasing enforcement against Bitcoin providers, while the Internal Revenue Service has increased investigations and compliance measures. The SEC stated on Wednesday that it had settled charges with Blotix, a UK-based company that used to operate CoinSchedule.com, a once popular website that profiled offerings of digital asset securities. The SEC determined that the company violated anti-touting provisions of U.S. securities laws by failing to disclose remuneration received from issuers of the digital asset securities it profiled. The move coincides with the IRS's increased compliance efforts, which include the addition of a question at the top of Form 1040 requesting taxpayers to disclose whether they received, sold, transmitted, swapped, or otherwise acquired any financial interest in virtual currency in 2020. The IRS has also been granted court permission to serve so-called John Doe summonses on popular cryptocurrency exchanges such as Coinbase and Kraken in order to obtain information about their customers' identities. The SEC's enforcement efforts are anticipated to increase under its newly minted chairman, Gary Gensler, who previously managed the Commodity Futures Trading Commission under the Obama administration, but they were also expanding under former SEC Chairman Jay Clayton. Digital assets and cryptocurrency were on the radar, and I believe they have already been assigned some offering fraud-type penalty examinations, but also enforcement actions that have been filed, said Ken Joseph, who served as a senior officer in the SEC's Office of Compliance Inspection and was one of the initial supervisors of the SEC Division of Enforcement's Specialized Asset Management Unit. However, it has undoubtedly intensified in recent years under Chairman Clayton. Chairman Clayton certainly had it on his radar. One of the topics he addressed from the pulpit was digital assets and potential fraud in that area. The SEC may begin investigating the fashionable sector of non-fungible tokens, or NFTs, which have sparked great interest since blockchain access to digital images and artworks began selling for millions of dollars at auction this year and grabbed headlines. Between stints at the CFTC and the SEC, Gensler lectured at MIT on blockchain, digital currency, and the convergence of finance and technology. There is some speculation that, given Chairman Gensler's background as a professor in the area of digital IP, there will be a more hospitable environment for digital innovation under Chairman Gensler, but I don't think anyone should expect the Commission's focus on offering frauds and fraudulent offerings of securities, in whatever form the underlying securities are, to go away anytime soon, Joseph said. Fraud prevention is crucial to the Commission's mission. The SEC may be able to provide more assistance to businesses regarding Bitcoin and how to comply with securities regulations. The predicate for an SEC review or enforcement case is going to be the discovery of a security somewhere in the process, Joseph explained. To the extent that digital currency stays simply that, a currency, the SEC is unlikely to have any big authority over that. The jurisdiction comes into play when digital currency, whether in the form of Bitcoin, Ether, or NFT, enters the area of being a security. The essential rule is that before a security offering is authorized, it must be registered or qualify for an exemption. The industry requires additional clarification on how digital assets should be treated in order to be categorized as a security, which can be addressed by rulemaking. He pointed out that the SEC has been using an ancient but well-accepted structure for analyzing a security known as the Howey test, which dates back to a 1946 Supreme Court case, SEC v. W.J. Howey Company, in which the underlying assets were oranges and orange groves. That methodology will now be utilized to determine whether a certain underlying asset qualifies as a security offering, Joseph explained. Some argue the framework is out of date, and they want additional clarity to bring it into the digital age. Joseph oversees the Americas team at Kroll that is in charge of providing compliance advice and support to registered investment advisors, registered investment firms, broker-dealers, and CFTC-regulated parties. Investment advisors are supposed to have compliance processes in place to detect and prevent infractions of the laws and regulations, and we educate our customers on how to do so, he explained. Another portion of the practice works as a consultant in a range of sophisticated securities concerns, securities as regulated by the SEC, so we spend time on clients who are under inquiry or review by one or more regulatory bodies. He anticipates that the SEC will conduct more investigations and enforcement under Gensler's leadership in the new administration. One shift we've seen is, definitely from the aspect of investigations, more active investigations by the staff, Joseph added. I believe that with any transition from administration to administration, there is generally a little bit of a slowdown while the staff attempts to figure out what the new commission and the new chairman's priorities will be, and I believe that lull has now passed. Chairman Gensler has stated unequivocally that he will be tough on enforcement. He just selected Gurbir Grewal, the former Attorney General of New Jersey and a former DOJ official, as the new enforcement director. He has indicated that climate change issues are high on his priority list, and I believe the examination program is likewise on track with its purpose, focusing on complicated securities and the like. He cited a recent case in the investment advisor industry in which the top compliance officer was charged alongside the advisor. I think that reopens the debate of whether individuals in the regulated sector might be held accountable for a breakdown in standards that would ordinarily only be levied against the entity, Joseph added. If this case is any indication, I believe it is clear that individual culpability is very much on the table. He also anticipates additional SEC activity in the near future centered on special purpose acquisition companies, or SPACs, as well as de-SPAC transactions, due to the big amount of money that went into SPAC vehicles and the large amount of money that is in the hunt for new acquisitions. We've already seen some investigations launched regarding estimates made by corporations participating in these SPAC transactions, and I expect that activity to grow up in the near term. In April, the SEC provided advice on accounting and reporting concerns for warrants issued by SPACs. The value of warrants issue is a slightly different problem from what may be alleged overstatements in future company prospects, projections, and business activities of SPAC transactions and de-SPAC transactions, Joseph explained. We hope you enjoyed watching and listening to this video. Please let us know your opinion in the comments area below. If you found our content useful, please like it and share it with your friends. Also, don't forget to subscribe to our channel and hit the notification bell for more crypto-related contents.